Good morning, everybody. Welcome to this Renewable Energy Performance Platform webinar on why fit-for-purpose shareholder agreements are critical to your project's bankability. My name is Carl Upston-Hooper. I am the General Counsel of Camco Clean Energy, and in that role serve as Company Secretary and Legal Advisor to the REP. I'm sure most of you are familiar with REP, but if you're not, it's a £148 million initiative funded by the Department of Business, Energy, Industrial Strategy of the United Kingdom, focused on getting small-scale renewable energy projects to financial close in sub-Saharan Africa. In the past 3 years, we have funded 25 projects in both the off-grid and on-grid space, representing about 350 megawatts of planned installed capacity across 15 different jurisdictions. But I am very happy to be joined today by a couple of experts on this topic. We have Joanne Elson. Good morning, Joanne. Joanne's there.
Good morning, everyone.
Morning. Joanne's a Senior Associate at Herbert Smith Freehills in London with 12 years experience in energy infrastructure focused on renewable energy in Africa. Her recent work includes advising the World Bank Group on documentation for its scaling solar program and advising the sponsors EDF, IFC and the Government of Cameroon on the large power plant being built in Natchigal in Cameroon. Also with us is Tinashe Makone. Morning, Tinashe.
Morning, Carl. Morning, everybody.
Tinashe is Senior Counsel at Sunfunder and an incredibly international guy, having been born in Zimbabwe, studied in South Africa, admitted to the New York Bar, and now based in London. Tinashe has a wealth of experience from several leading law firms, including most recently Trinity, and crucially for this webinar is able to combine that experience with the perspective of Sunfunder, a leading lender in the space. The format of this hour is that Joanne will lead us off with a presentation, and then we'll have a brief panel discussion before we open it up for your questions. I'd like to, perhaps before we start, just highlight a few practicalities. To avoid disruptions, you're all on mute, but we really want your Q&A. So down the bottom or top of your screen, depending which hemisphere you're in, there will be a little icon that's labeled Q&A. At any point, click on that, ask a question, we'll collate them and we'll get to them in the attendee Q&A session. It would be helpful if you stated your name and organisation so that we know who we're taking the question from. And I also note that amongst the attendees are various members of the REP Investment Committee and Board, and I'm sure they are vastly more interested in your questions than our presentation. So please bombard us with questions. That would be great. Towards the end of the webinar, and certainly before you go for lunch, I would be very grateful if you completed the very short poll about the webinar. Again, there is an icon labeled poll. It has a couple of questions. Without metrics as to whether these sorts of things are helpful, we're not really able to continue this sort of capacity building in the future. And the final point is that this is being recorded, and we will produce a written summary very much focused on your Q&A. Both will be published on the REP website. So if you miss something, don't worry, you'll be able to review it later, and hopefully you'll also be able to share this with your colleagues in the coming days. So without further ado, I'd like to invite Joanne to start her presentation.
Thank you, Carl. Thank you for that lovely introduction, and thank you for inviting me to join both you and Tinashe today. Hopefully everyone can see my presentation on their screens. I'd like to welcome everyone this morning, and hopefully you are sitting somewhere and able to relax and enjoy the next hour. Okay, so shareholders agreements. So we are going to look today at the key points which developers should consider. This first slide illustrates a diagram of two shareholders incorporating a new special purpose company to undertake their joint venture. Now, this company will have its own separate legal identity, separate from its shareholders, and therefore it can buy and sell assets in its own name and enter into contracts in its own name. So the parties, the shareholders, will enter into a shareholders agreement to govern their relationship with respect to this special purpose vehicle and obviously their joint venture. So the key features we've listed here are that the assets and the business is owned by the joint venture company and not by the shareholders themselves. There will most likely be limited liability for those shareholders. However, there will be shared profits from the company sent up the corporate chain by way of dividends. This is a very simple structure. You may, in your projects, require more complicated ones. For tax reasons, you may have holdcos in various jurisdictions, or you may have a portfolio of assets, which means you have either more than one SPV or lots of bubbles at the bottom with different ownership structures. So as Carl and we've all indicated on the LinkedIn notices that you may have seen before you signed up, what we're going to look at today are the role of and importance of governance in your shareholders agreements, your rights as developers and the obligations as developers, and the overlying bankability issues and important provisions that lenders will be looking for if you are looking for that third-party debt to help you on your way. So when we look at governance, we're going to look at things like the provisions that you have in your shareholders agreement for dealing with conflicts, either conflicts of interest, conflicts of management at board level, and how that allocation of risk is shown within the contract. We'll also look at the obligations you have as shareholders and developers to put in any capital contributions, how you'll deal with cash calls in the future, potentially for cost overruns in construction, what you will do if there's a deadlock, if there's a disagreement between you and your other shareholders or at board level between the directors. And then what you do if one of the joint venture partners wants to leave the relationship. How do the contracts set out those provisions? And as I mentioned, the bankability aspect. So what the lenders will be looking for in all of this in terms of good governance and the appropriate risk allocation you've set out, but also from their perspective, ensuring to the extent they will require security over your project, that they are able to do so without any barriers being included in your corporate documentation. Lenders will also be keen to ensure that all of the assets that they're intending to fund when built or as you go along the way are held within your project company and not by the shareholders themselves, to ensure a nice clean structure for them to provide funding to. So, governance. Here we're going to look at the board composition firstly. So you as developers and as shareholders now should consider how you set up your board, thinking about things like nominees. How many nominees should each shareholder have? For example, if you're a minority shareholder with a 10% interest, you may only expect to have one nominee as a director on the board. However, if it is a 50-50 joint venture, you'd expect the parties to have equal nominees on the board. The voting rights of each director will usually be proportionate to the shareholdings. So this can be achieved either by one director gets one vote or through weighted voting. Voting thresholds are another point to consider for certain key decisions that you may need to make along the way during the life of your project. Those decisions may require a voting threshold of over 50% in order to protect any of those minority shareholders. We'll look at that in detail on the next slide. You should also decide if you're going to appoint a chairperson for your board, and the responsibility for who makes that appointment, whether or not that chairperson has a casting vote. It's obviously a very powerful position to be in, and therefore it should be considered by all parties properly and decisions not made lightly. Quorum considerations, these seem obvious to start with, but are quite often overlooked or perhaps not thought through thoroughly at the start when you put together your shareholder agreements. Here, it's just useful to think how you expect a valid board meeting to actually happen in practice. How many directors do you require to be there in order for there to be a valid quorum? Do they actually have to be there physically? Can they join by phone? Can there be proxies for that person if they perhaps can't make a meeting? All of these things are useful just to consider upfront and quickly and contain within your documents. The last point we've got on the slide here to consider with relation to the composition of your board is, depending on the jurisdiction you are in and the type of project that you're looking to undertake, there may be a requirement for a local content. So there may be a requirement for a director to represent a public entity or utilities interests on the board of your company. And if that's the case, you should consider early on how you're going to meet that local content requirement and ensure that the governance provisions continue to represent the appropriate risk allocation. Conflicts of interest between directors or between the shareholders are something that we often see. We've had questions on this many times. So, for example, it's common for a joint venture to be made up of one party who is going to construct the project and maybe one party who's going to fund the construction of the project. However, in order to ensure that that relationship is kept appropriate, it's important to ensure that the project company that will be entering into the contract with that shareholder in its capacity as an EPC contractor considers how the decisions are going to be made with respect to that contract. And the key point here is to make sure that any shareholder or directors representing that shareholder on the board of the project company can't be involved in the decisions that are made in connection with that contract. Now, clearly, that's a very important contract and is worth, can be worth a lot of money to the project company. However, sometimes we have questions along the lines of, well, you know, I'm only in this because we're friends, we want to do this together. Why should I be excluding them from this decision, which is clearly a very important one? And the answer will always be that although day one you're friends, things change down the line, and you can't guarantee that everyone will be rational when things perhaps take a turn for the worst or potentially even for the better in terms where the contractor maybe sees the grass is greener elsewhere. So we would always advise, and lenders will always be looking for provisions in there to protect the decision making in relation to those key contracts. Other lender requirements will be likely to be thinking about their security position, and they'll want to ensure that there's nothing in your shareholders agreement or your corporate documentations which give any of the directors an ability to refuse to register any share transfers in an enforcement scenario, or even the veto right at the ability for the project company to grant that security in the first place. So as I mentioned, we were just going to take a quick look at the key decisions where you may want to increase the voting thresholds at the board level. And as I said, these decisions may have a 70 or 80% threshold, which afford protection to the minority shareholders you may have. This is usually by way of a list of what we call reserved matters. and those matters may be in relation to decisions to be made on the winding up of a company, or changes to your accounting policies, budgets, business plans, the key underlying business decisions that could be made. However, it's worth noting the longer your reserved matters list is, the higher the risk potentially of a deadlock down the line. And so you have to balance that protection of your minority shareholders against the chance of there being a dispute on those decisions further down the line, which could lead to delays or potentially costs. Right, so some of the rights and obligations we wanted to touch on today that developers will have and want to see in their shareholders agreement. The key one is money, funding. The lenders will be looking for robust funding mechanism in the shareholders agreement, reflecting the business plans of the joint venture. So usually that initially before construction we'll be looking at the capital contributions that are needed to develop the project and move into the construction phase. Most likely the equity will have gone in first, and then you may have even put more equity in than is perhaps necessary as a ratio to your debt that you're looking for from the lenders. However, in some circumstances, if you're lucky, lenders may agree that shareholders can make their capital contributions on a phased basis, perhaps at certain milestones of the project, which would be in pro rata proportions to the debt that you're looking to draw down at that phase. Or if you're even luckier, and I haven't seen this for a very long time, but it has happened in the past, you may be permitted to put your equity in after you've drawn down on your debt and towards the end of the construction phase. So that's what the lenders will be considering. But as a shareholder, you should also consider each other's creditworthiness and think about whether you need any protections or mitigations for your joint venture partner perhaps not putting in their capital contributions at the right time or ever. Now, as I said earlier, day one, you're all friends, and I'm sure there's no expectations that someone may not be able to put their money into the company. However, to the extent that there is a possibility of that, it's worthwhile, and lenders may require this because they tend to be more conservative than the shareholders, that you consider whether there is a need for a letter of credit or some sort of liquidity backing, a cash account somewhere that can be drawn on in the event that the shareholder cannot or does not make its capital contribution at the right time. Another type of contribution that we sometimes see, and this will depend on the type of project and the jurisdiction you're working in, is that there could be a contribution made in kind. This usually, but not always, relates to land. So if you've gone into a joint venture with someone who owns the land and their contribution is that piece of land, then you must be able to show to your lenders, and obviously for your own purposes, that you've credibly valued that land, and the amount that's put against that value makes sense in terms of the capital contributions and the risk allocations. Just quickly on ongoing obligations to fund, as a developer, you will obviously be seeking not to have any open-ended or uncapped funding obligations. You will want to be able to make those decisions by yourself at the appropriate time.
Yeah.
However, the lenders will be wanting to make sure that there is a robust cash call mechanism or an ability in the shareholders agreement for shareholders to be required to put in extra cash for certain scenarios. For example, if there is a cost overrun towards the end of construction, the shareholders may be required to put in a certain percentage, whether that's 10%, 20% will be negotiated. However, from a developer's perspective, you should ensure that there's at least some cap on that. The last point on the slide here is just making sure that you, as a developer, consider the future of what it is you're expecting your business to do, and to the extent that you may want to either purchase further assets in the future or develop further assets, then you should at least allow for that in your documents. So what happens if you have all these funding obligations in your contract but one of your shareholders fails to fund? The lenders will look for clear fallback provisions. Is there an obligation on the other shareholders to meet that funding gap? And what would the remedies be against the sort of defaulting shareholder in this situation? Would there be some examples of these remedies? Could be equity dilution. So you may decrease the percentage ownership of that shareholder. There could be an economic dilution. So you would decrease their economic returns or their dividend amounts. Or you would remove their voting rights at board and shareholder level for a period of time. Each of these remedies usually depend on the extent of the default and you know, whether or not they catch up with their payments. So as I mentioned earlier, what do you do if there is a deadlock, if you can't agree as shareholders on the board to a key decision? So deadlocks could arise where there's a fundamental matter at stake and the board can't make the decision one way or the other. I think something we've seen before is, again, in relation to land, where there was land already, a site prepared for the project. However, there was a problem with that site that was unforeseen, and the decision to be made was whether or not to carry on and spend the money to rectify that problem or move the site. So these tend to be decisions that you can't think of day one, but you as shareholders and lenders will want to ensure that you've actually thought about what happens if there is a conflict and the project company can't move forward because it can't make a decision. One point here I've put on this slide is gaming risk. I don't know how likely this is, but I guess that the point here is that parties won't always act rationally or may not act in the way that you expect in certain scenarios. And so they might deliberately cause these deadlocks for tactical reasons, even if it involves a short-term financial loss to them. So the point here is you shouldn't assume that they'll always act rationally, and you should consider what happens if you can't agree. The lenders in particular will want to see these robust provisions, and the reason for that is to ensure that they've got a clear conflict management procedure set out, which is tailored for your project and the demands of your project, which allows the project to continue, and critically for them and for you, the preservation of the asset value. And from a lender's perspective, it's always to ensure that the project gets into operations and starts the revenue stream coming through in order for them to be repaid. So shareholders' agreements commonly contain these deadlock provisions to resolve those situations, but they do come with pros and cons, and so it's worth considering them carefully. A point here to make is that parties rarely rely on those contractual provisions in the shareholders' agreement, which sounds counterintuitive. However, they are important as they act as the starting point for negotiations, and therefore they impact the parties' respective bargaining power at the time. So although it's very difficult to future-proof 100% all the scenarios which may lead to a deadlock, it's important to at least have thought through how you will at least start those negotiations at the time. So this slide sets out some of the ways that you can deal with a deadlock. If there's a legal dispute, perhaps you will need to take the issue to an expert for expert determination. So that could be, you need an engineer, an independent engineer, to agree whether or not there is an issue with the design for the construction or not. It could be a legal matter. Potentially there's an expropriation of shares or something that would require you to take the dispute to arbitration or the courts. However, most likely it's a commercial dispute. And so the ways that you would think about dealing with those disputes would be potentially to have a casting vote. So as I mentioned earlier, you could give the chairman that vote, which would come to a swift resolution, but obviously puts a lot of responsibility on ensuring your chairman is the right chairman. Or there is a procedure where you could have an exchange for a trade-off. So the minority shareholder would be overridden on a matter they consider to be fundamental because the majority shareholder exercises the casting vote. But the trade-off would be that the minority holder has a right to put their shares to the majority holder at a valuation plus a premium. So the premium would need to be sufficiently large to discourage that majority shareholder from exercising their casting vote in a situation where it wasn't the right thing to do. The other options could be a put or call option. So a put option would allow a party to force the other to buy its shares. A call option allows a party to force the other party to sell its shares. These can be useful if one party is a natural buyer for the project, but you should pay particular attention to how you value those shares, as the exercise of these options can leave the parties at the mercy of a valuer. Russian roulette. Now, this is a power play term if ever I've heard one. So a Russian roulette provision requires one of the two deadlocked parties to serve a notice on the other party, and the serving party will name an all-cash price at which it values a half interest in the business. The party receiving the notice then has the option to either buy the other party out or sell out to the third party at that price. So it's a popular exit mechanism when you've got a real 50-50 joint venture, and it encourages a realistic exit price. But for obvious reasons, it's rarely executed in practice. It is a roll of the dice. It is Russian roulette. There is an element of risk, particularly if the business is a core business of the party, or one of the parties is vital to the joint venture, or if one of the parties would be unable to raise the money at the time. But it is useful to set a realistic exit price without the need for any valuations, and the party wishing to exit will not wish to stipulate the sale price, which is more than it would itself be prepared to pay for the business. The other alternatives you could have would be an auction or a trade sale, essentially just selling the assets or a portion of the shares to a third party. So just looking at exit, so this is not necessarily where there's a deadlock situation, but just where a party wants to leave the joint venture. Those triggers could be maybe there's been a continuing breach by another party, one of the shareholders hasn't funded its capital contribution, there's been a change in control higher up in the chain of that shareholder, so you went into business with a party who was whose parent company was perhaps an international developer in your market and has since sold that subsidiary elsewhere, and you're not happy with that change in control. Insolvency, someone's gone bust, or it's not as profitable as you expected. So these, in addition to deadlock, may be a situation where you're looking to exit the joint venture, and so your shareholder should include mechanisms for doing that. Now, the lenders will be very keen to ensure that these exit provisions are detailed and protect their expectations for the project as well. Now, bear with me on this slide. There's a lot of terminology, and I know we've already been through a lot of terminology, but I'll take my time and go through them. So, standstill lock-in period. So lenders will often require a share retention mechanism to ensure that certain shareholders remain in the project for a certain period of time. For example, if there are key personnel that a shareholder brings to the project, and those personnel have the skills and have been here and done that and know exactly how to operate your project, they may be required to remain a shareholder for a number of years, certainly through construction and potentially post-construction into operational phase. Preemption rights. Parties may wish to protect the private nature of their joint venture, so they may not want third parties coming into their project. There are various ways of incorporating preemption rights into your projects. I've listed some of them here, but given time, I probably won't go through all of them in detail. But essentially, it's the rights of first refusal or first offer, or veto rights on any third parties that you may want to sell to. Lenders will be keen for at least some operation of those to ensure that the project remains with those parties with the most knowledge of the project. Drag and tag provisions, these are incorporated to protect the shareholders, whether they're majority shareholders or minority shareholders. So a drag right would be attractive for a majority shareholder who may have found a third party to sell its shares to. They give the ability of that majority shareholder to compel any minority shareholders to sell its stake to the same buyer simultaneously. The drag along acquisition here is made at the same price and on the same terms as what the majority stakeholder has negotiated. So although it's attractive for majority shareholders, it is protective for those minority shareholders too. Now, a tag right is where a party, usually again the majority shareholder, wishes to sell its shares, but such sale would result in a change of control of the project company. The minority shareholder here can exercise its right to tag along with that sale, and as a result, the majority shareholder will not be able to complete its sale until the buyer also buys out the minority shareholder, again at the same price and on the same terms. We've already touched on and put in call options which may be included for an exit after an agreed period or certain key milestones have occurred. In certain scenarios, there may also be the ability to go for an IPO, an initial public offering, or a stock market launch of your project, but obviously that will depend on the jurisdiction and the type of project. Non-compete clauses, we're on the second to last slide now. So these are just a list of these potentially are commercially obvious, but don't always make it into the shareholder agreement. Lenders, will look for these, but it may not be a deal breaker that they're there. So a non-compete clause typically operates to stop joint venture parties from engaging in business with competitors for a specified period within a specified area, and that's usually to ensure the success of the project in hand. Non-solicit clauses are very similar, and those restrain the participants from poaching each other's employees, which can be a real concern where there are key personnel who are bringing a number of skills to your project. There are some legal, usually depending on the jurisdiction, and you would have to check with the local lawyers where you are, but the non-compete clauses must be reasonable and so that it's in scope and territory for them to be enforceable. You should, if you are looking at these clauses as a shareholder, consider whether there are any carve-outs that you need. For example, any incidental business which happens to fall within the category of your non-compete provision, you should make sure doesn't get captured in order to allow you to continue to operate. And finally, although I've kept this slide to the end, really I've tried to bring each of the governance or obligations and rights of developers back to what the lenders would think at any moment in time. So the key bankability issues really are everything we've discussed, and with an emphasis on the ability for those lenders to take and enforce the security that they would be looking for. and ensuring that the assets are at the project company level. A couple of other points here I thought would be worth mentioning are that the development costs that you may have already incorporated into your project should be considered, how you may share these and how the project company will repay these, whether it's during construction or later. Also, dividend policies, to the extent that you set those out in detail, the lenders will want to see that there are restrictions on the ability of your company to pay those dividends, particularly during the construction phase, but certainly while the debt is outstanding. So thank you, everyone. I know that was very a lot of detail in a short period of time, but hopefully some of that has been helpful. I'll now pass back to Carl and we'll, I think, move on to the panel discussion.
Thank you, Joanne. I think it takes a lot of clarity of thought and experience to such a broad subject in the allotted 35 minutes, which you've done fantastically, and hopefully that sets us up for more Q&A, which we've got coming in from the attendees. But before we do that, I was just hoping to start a bit of a panel conversation about a couple of things. And I guess the first is a relatively basic question. I think the attendees please accept that we have a real range of experience on this topic. Some of you are asking quite detailed questions, some of you are asking more introductory type questions, so we need to kind of balance out how to do all of this. But in your joint venture diagram, what happens if the joint venture company doesn't have a shareholders agreement? What's the action there?
Well, yes, I guess if you don't have your shareholders agreement, you're relying on your corporate documentation, so your articles and your memorandum of association, which, if anyone's ever looked at, can tend to be, either if you're in the UK, very long-winded, but they don't necessarily deal with all the issues that are important to your project and your business. They are not tailored in any way, so they're not ideal for protecting shareholders' rights, and lenders will certainly be looking for more than that.
Yeah, and I guess the other aspect to add to that is the other document, whereas your shareholders agreement is a private document. Yes, you will need to disclose it to end of part of the due process, but you can outline how you wish to run the company outside the public gaze, which is another advantage of shareholder agreements. Sasha, you've been sitting there quietly for some time. From a funder's perspective, how do you generally at Sunfunder approach shareholders agreements for the projects that you're looking at providing debt to?
Thanks, Con, and thanks, Joanne, for that really comprehensive run through all these issues. I will do my best not to sort of go over the same ground, but maybe sort of from a practical perspective, I think where we start is to distinguish two sorts of projects. So when we're working on a larger project where there is perhaps it's a little bit more complicated, construction will be longer, we expect money to come in from the equity anyway in phases or at certain milestones, or there's a real risk of cost overrun, then yes, the governance is really important, but where we might start from is asking ourselves, are the shareholders obliged to inject equity? And if they don't, what mechanisms are there within the documentation to compel them to do so? Is there a requirement, for example, I think Joe mentioned this, to post some sort of credit support, like a letter of credit, bank guarantee or something like that? So that's sort of the larger project. When we have the smaller projects, and this is really sort of where sort of the vast majority of the work we do at Sunfunder is sort of on the energy access side, even on the commercial and industrial, so the C&I space. Generally, these projects will have limited execution risk. The technology is fairly sort of robust and not super complicated. You know, you know, they're using tier one suppliers for, you know, all the kit, the inverters, solar panels, batteries, and the like. And very often the money from the shareholders is required to be injected up front. There is a concern that, you know, your shareholders remain sort of, you know, robust and have, you know, fairly deep pockets. But because the money's gone in, it's less of a risk than with the larger projects. In that instance, our focus tends to be on the governance issues. Again, Joe touched on these, but, you know, some of the concerns we'll have as well. You know, have we done KYC on the present shareholders? What happens when new shareholders come in? Are we comfortable that they won't be politically exposed or fall foul of our AML requirements and so on? So that becomes an important part of the analysis. We also look at things such as change of control, right? So if the shareholders on day one that we're funding this project based on, if they move on in the future, are we comfortable that the project company will retain both the funds and the expertise to execute that project? So do we, for example, want to insist that the documentation ties in certain existing key shareholders and or members of management into that project? We are funded, a lot of our funding comes from DFIs and impact family offices and other impact investors. So we need to think quite hard about things such as, you know, prohibited activities, what sort of projects this company and also the shareholders have been involved in the past and may be involved in the future. So the governance side of things takes a greater prominence with the smaller projects versus, I think, the money on the larger projects.
Thank you, Tinashe. I mean, I think that kind of naturally bleeds into a question I'd like to come back to you on, which is really the whole raison d'etre of this webinar, is how do these agreements impact bankability? And I know that Joanne has given us a great summary of structures and things you need to think about and issues. But if you could give us some practical examples of how shareholder agreements impact bankability from your experience.
Sure, Carl. So the starting point for us, assuming sort of we've cleared those, you know, first hurdles of, you know, do the shareholders have money? Will they be able to put money in? Are we comfortable with you know, the broad KYC, AML sorts of issues, sort of at sort of tier one issues? The next question sort of I would have is, can I as a lender take security over the project assets? One of which for us, a key one, would be the actual shares in the company that'll be executing that project. And very often, and Joe, you mentioned this, but very often they are certain sort of mechanisms like rights of preemption that could potentially frustrate our ability to take, firstly, take effective security, but also enforce security over those shares. Interestingly, sort of one thing we're working through at the moment is local content. So we've got a scenario project where there is a requirement in jurisdiction to have a local shareholder as one of the owners of the projects. And one of our key items of security will be the shares in that project. Now, one of the questions we're asking ourselves is, well, in a doomsday scenario, if we ever have to take over that project, are we comfortable that the existing, we can partner with the existing local partner, or would we be able to find a local partner in time to bring them in to hold shares alongside us? So that's an important consideration. Another one actually is capital structure. We've looked at a project which is, you know, very well capitalized. The shareholders have put significant amounts of equity into the project, and we've all assumed all along that there were no issues. And, you know, we got an auditor's confirmation that it was a going concern. So everything seemed fine. But when we dug a little bit into the structure, we realized that actually the equity had been injected mostly by way of shareholder loan. Now we were comfortable that we could subordinate the shareholder loans to our loan coming in, so they wouldn't, you know, compete with us. But there was there was a concern with thin capitalization. There's a real concern that when you looked at the equity, when you looked at the shareholder loans as debt rather than equity, which we understand now is sort of in that jurisdiction is how one must do that analysis, then the company was firstly thinly capitalized and possibly also in danger of being actually insolvent. So that's something that's worth thinking about really early on in the bankability analysis. And I think in the last one, and I've mentioned this before, but I think it really is important for us as Sun Funder, because we view ourselves as partnering with our sponsors, and our sponsors are really key to our projects, and we need to sort of balance, on the one hand, sponsors' flexibility or the sponsor's desire to have flexibility to move on to other projects and to cash out and to bring other people in and so on, versus our sort of ethos of partnering alongside our sponsors. So that's always, those two, we need to hold those two in tension, right? So we want our sponsors to remain committed to the project, not only because of their deep pockets, but their know-how, their technical expertise, and the impact that they're having in that particular jurisdiction. And we balance that with a sponsor's desire to bring other people in and to cash out. So we will have some measure of restriction on the ability to sell their stake in a project. So they need, to retain some skin in the game, but we do want to give them a little bit of flexibility to bring other people in. So that's always a really interesting sort of discussion between ourselves and the sponsors about sort of how we'll treat the project going forward. So I think those are sort of some of the headline features on the bankability analysis that as a lender sort of are unique to us, both as a lender but also as an impact investor.
Yeah, brilliant. Thank you, Tinashe. Joanne, I guess we're all native English speakers. Me with a bad New Zealand accent and apparently a poor internet connection, but there's an awful lot of project development that goes on in Francophone Africa that operates under a different legal system, the civil code system. To what extent do you feel that the kind of issues that you raised are replicated in that system, or is there anything that you would kind of highlight as distinct about the civil law system of shareholder agreements?
Thanks, Carl. I think in relation to shareholder agreements themselves, there aren't particularly any differences in what we've touched on today in terms of things that you should consider. One of the key thing, or a couple of points I would say in Francophone jurisdictions, one in particular with respect to share security, so maybe a point for lenders, but a point for developers to be aware of, is that there can be extremely high registration costs for the registration of that security, which may or may not, depending on the size of your project, make it worthless, essentially. But the key concern that we're seeing at the moment on projects in Francophone Africa is relating to the issue of offshoring of bank accounts, repatriation of revenues out of the country. This is becoming more and more difficult, and the relevant central banks are cracking down on it. So this is really the sort of the bigger concern that we're seeing at the moment.
Okay, true. Okay, well, thank you for the panel discussion. I think we've got 10-15 minutes left, and we have received via Ring Central a whole list of questions, not all of them from Michael Feltner, it must be said, but we'll try to get to as many of these as we can, and I'm just going to throw them at you guys slightly randomly. One issue raised by Andrew, and I think this is probably best question to you, Joanne. When you have a decision or a dispute that's testing the shareholders' agreement, and perhaps even the outcome of the negotiation is contrary, it's just a negotiated outcome contrary to the dispute resolution process outlined. Do you need to kind of re-document your shareholders agreement, or can you just say, okay, we agreed X and we're going to leave the shareholders agreement in place, but we're agreeing an exception?
So the short answer is yes, you can agree an exception as long as all the parties concerned sign up to that exception. I would always recommend documenting the exception, noting that you are referring back to your shareholders agreement, but that you are all in agreement on this exception to that in these circumstances. I wouldn't recommend doing that orally, because inevitably someone might decide that was a bad decision down the line and bring you back to your original shareholders agreement. So yes, you can do that, and in most jurisdictions, and I think all of the ones that I've worked in, there's no restriction on the sort of contractual arrangements that you make amongst yourselves. I would say if it's something you think the lenders or any potential guarantors or guarantees are involved, that you should make sure that you get their approval, or at least inform them of the decision you're going to make, to make sure there's nothing, there's no change that you're making which may impact either those guarantees being given by third parties or the lender's happiness with your project.
Yeah, great. Tinashe, Michael has a question about lender step-in rights. There is, of course, a complicated relationship here between shareholders agreements, direct agreements, step-in rights, the underlying project agreements, which is probably a webinar in and of itself. But perhaps for the benefit of the broader attendees, how do you feel that lender step-in rights work as part of shareholder agreements versus having overarching direct agreements, etc.?
Yeah, I mean, it's something that we've been sort of, actually, it's a topical issue internally at Sunfunder, because we are working on projects where it's really difficult to get a direct agreement. And so one approach that we are working through is the process of stepping in indirectly via your shares. So if you have an enforcement event and you foreclose on the shares that you hold as security, you then become the de facto owner of the project and everything that's owned by that project. In that instance, ideally what you'd want is you'd want to disapply all the restrictions in the shareholders agreement, things like rights of preemption and so on. So it's important right at the beginning when you do your bankability analysis to disapply those. So you have special resolutions and amendments to the corporate docs and the shareholders agreements that would allow you to effectively take over that company. So I guess the short answer is if I'm stepping in as a lender into a project via the shares, I want to control that company, and I don't want to be restricted by a shareholders agreement. So in that instance, shareholders agreement will become bad for me as a stepping in lender.
Yeah. Maybe just stay with you, Tinashe, and you did touch on this, I think, in one of your answers to questions, but a lot of these projects are small projects, and I think the attendees on this webinar are, not the NLs of this world. And often they're driven by the personal vision of a couple of people. If one of those people has other opportunities or circumstances change, key man, risk is real and live for some of these deals. How do you typically address that when you're looking at lending to a project? And do you see that in the shareholders agreement, or do you see that elsewhere? You're right, and it's a tension, right, Carl? Because you don't want to tie people who don't want to be involved in that project to that project, right? Because it's just not, it's just, doesn't sit well with us. But you're right, a lot of these smaller projects are funded off the back of the vision, the money, and blood, sweat, and tears of key people.
So look, so there's no easy answer and there's no simple answer except to say that it's a tension and it's something you need to kind of, it's something you need to constantly grapple with. I mean, some solutions might be, for example, to distinguish the construction and the operation and maintenance, right? So if you've got a project that can sort of stand alone post-construction and have a third party do the maintenance and operation, then in that instance, it's easier for somebody to step away because it's up and running and sort of can be sort of fairly sort of self-sustaining, versus sort of some of, for example, the ESCO projects that you might look at where your sponsors are absolutely key to the continued success of the project. So look, it's a challenging one. There's no easy answer. For us as a lender, where we would look to sort of enforce any rights, any key man provisions or any changes of control or that sort of thing would be in our debt documents because we're not party to the shareholder agreements. So that wouldn't really sort of give us as much comfort as having it in a document that we are party to and can enforce.
Exactly. Joanne, sorry, you want to add to that?
Yeah, I was just going to add to what Tinashe was saying is that in what I've seen in those situations where one of the key players is contemplating how they might be able to exit despite the lenders not really wanting them to, they have been able to negotiate provisions which set out parameters. So if they come to you with someone who they can show to you the lenders has the requisite economic and ability and the technical ability to carry on the project as at least as good as they can, then in those circumstances quite often the lenders are forced to give their consent at that stage.
Yeah, great. I think a couple of fairly technical questions for Joanne now. Sometimes people are uncomfortable with the enforcement of onshore pledges. Country risk is an issue in a lot of these jurisdictions and are more looking at often in tandem taking offshore pledges over holdcos in Mauritius or the UK. Do you think that there is distinctions between civil law and common law systems around that decision making, or do you think it's jurisdiction specific or more kind of broader risk of the group, or the famous option D, all of the above?
It certainly depends on jurisdiction. I don't think it's necessarily a key difference between civil and common law. I think it does depend on the jurisdiction you're in. And we often see the whole code structure being set up for exactly those purposes. But what I would say with that is, again, to check locally how that would be construed, because even though you've moved it perhaps one level up, they could the local law could very much just look through that and say, no, this is a change of control of our local company, and it falls foul of whatever it might be, consent, or in some cases it's just a notification process. But there's no easy answer to say one process fits all. You really do need to look at it on jurisdiction, and I've seen lenders who are perhaps surprised, even after having done their initial due diligence as to how the process may work, have to take a sort of a risk analysis at that point in time on whether or not to go forward with the project. Yeah.
Great. We've got time for another couple. I think if we just stay with you, Joanne. Choice of law. I'm sure that Tinashe and I both want all of our loan agreements governed by English law, and that's generally a complete red line if you actually want Sunfunder or Rep's money. Shareholder agreements in relation to local entities governing local governance sort of thing. So you often end up with a tension between the governing law of the financing structure and the de facto governing law of the shareholders agreement. I mean, is it even possible to have your shareholders agreement governed by English law if it's a Kenyan company?
Yes, no, it is possible. you will need local law advice as to if there is a strong veto right, and we're actually having this discussion currently in Malawi as to whether or not the shareholders agreement for the project can be governed by local law or English law, and there's a discussion ongoing even between the local councils for both sides of the the lenders and the project company itself. So you're right, there is a tension there. On balance, if there's no legal requirements, it depends with the balance of power, and lenders quite often win that. And their shareholders agreement will be governed by the law that they wish it to be. But I would say for lenders that it's not always the right thing to do, and it is worth taking that local advice and actually weighing up the decisions, and the rest of your project documentation and your security and the whole structure of the deal should also be there to provide you with the protections you're looking for.
Okay, I think we're a couple of minutes over time now, so let's take one more question from the attendees, and then Tinashe, I might come back to you for a bit of a wrap. But I think this is actually probably a question best addressed to Tinashe. The sponsors generally want to exit deals, get their development premium, go off and do the next thing at COD, right? Commercial operation date. And lenders probably want them to hang around for a bit longer. What's your starting point for that conversation, all else being equal?
Thanks, Carl. I mean, I think it comes back really to whether or not the project can continue to stand in and of itself without the continued sort of heavy involvement of the sponsors, right? So I do like, Joanne, I like your solution of having sort of key parameters. So you sit down and you say, look, it's not just COD, it'll be COD plus 6 months, provided the project is meeting these 6 criteria, and provided that there's a reputable O&M party that's coming in and we're comfortable, has taken handover. That sort of conversation is those sorts of parameters are the sorts of things that we would be looking for to allow an easy exit. Yeah.
Thank you, Tinashe. Just before we wrap up, can I ask everybody again who's had the benefit of Tinashe and Joanne's time for the last hour to go to the little poll icon down the bottom of the screen and give us your thoughts. We need these metrics. We really do need you to respond. We hope that you respond positively, but we really need you to respond in order to continue this webinar series. So please do that. In terms of closing, Tinashe, I think we've tried to keep this real, and you know the market, you know the type of barriers that people face, that they are struggling to get these deals done in some of these places, and really all helpful advice is often gratefully received. So what would your parting words of advice be to shareholders in order to increase the bankability of their projects, in order to get them funded and built?
Thanks, Carl. I've got maybe 5 things will be my parting words. I think the first one is take your time, think long and hard about how you're going to develop the project and how you're going to fund it. And consider what sort of structure will work not just for today, but will work for tomorrow. Does it make sense, for example, to do the project in country, but to actually raise your equity and your debt outside the country? So in a jurisdiction, we often see a place like Mauritius as a sort of place where you have your shareholders agreements as well as your debt coming in. So have a think about whether that sort of structure is appropriate. I'll also say, do take legal advice and tax advice. In particular, we're seeing people get really unwound by tax advice, the tax consequences of the decisions that they made up front. things like really expensive secondary tax on dividends, restrictions on things, things like transfer pricing, thin capitalization. Those are real issues that we are seeing. So do take advice on those. One other one is embrace SPVs. And Carl, this is something you and I have had a conversation about, where you'll see people do multiple projects under the umbrella of one company, and whilst there are real advantages from a pooling of risk and so on, there are some advantages. There are actually also significant disadvantages, right? Because even though you can have cross collateralization, you also have cross contamination. So if you have one project that is underperforming and has real issues, that could potentially collapse the whole structure. So if it's appropriate and feasible, do consider having separate SPVs for special purpose vehicles. For your separate projects. And finally, some really practical considerations. Do spend some time thinking about how you deal with the practical issues such as shareholders meetings. Do you have to have physical meetings? Can you pass resolutions via round robin resolutions? Do some of your shareholders need, who are DFIs or corporate institutions, do they need internal approvals before they can sign off on a project in which the company is undertaking? We've actually had some issues where we've had delays because shareholders just aren't able to pass resolutions because they need to physically sign documents. People need to sign the same document or need to be in the same room. So, and I'll leave you with a West African proverb, which is haste and hurry can only bear children with many regrets along the way.
Thank you, Tinashe. Thank you very much. On that note, on behalf of, I think, over 100 attendees that we had during the webinar, I'd like to thank Joanne and Tinashe for their time today and the time that they put into preparing for today. Just to re-emphasize, please do the poll. And a copy of this webinar as a recorded video will be available on the REP website. I will speak with Joanne as to whether we can also get a copy of her PowerPoint, and we will prepare a summary document outlining the questions that we had, including the ones that we weren't able to get to, and we will post that on the REP website. So yeah, thank you. Have a great day. In these interesting times, please also stay well, and hopefully we'll be hearing at the next webinar. So thank you very much. Bye-bye.